Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and let's just go ahead and get right into this evening. We are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the broadcast network operating, and the shows, the information, the revelations, the discussions, and the guests and the hosts on the other shows. We need your help to keep the broadcasts coming. So, if you enjoy the information, the revelations, the discussions, the lectures, the guests and the hosts on the other shows of the network, we sure would appreciate it. If you could find your way over to libertyworksradionetwork.com, get signed up as a monthly subscribing member, and help spread the word of liberty and constitutional republic and the return to constitutional law that this network is teaching across the country, and it is one of the few teaching rather than just reporting. So help us and spread the word. LibertyWorksRadioNetwork.com. Get signed up and spread the word. And if you need help understanding or you want more education on the subject of the maladministration of the federal income tax by the IRS, of course, you want to find your way over to taxfreedom.com and start reading, because everything I've been lecturing about on this show for the last 15 years is all explained there. And the Supreme Court has said we're correct. And the federal government, well, they didn't actually say it, but you read between the lines, they said it. The federal government's been lying to the American people through the IRS, the DOJ, and the federal courts for 50 years. It's a lie that it's a direct tax under the 16th Amendment without limitation. That's a lie. It's been a lie for 55, it's been a lie since 1955 in Glenshaw Glass. The entire federal income tax system is based on a constitutional lie, a fraud. And they know it's a fraud, and they're still doing it, and they're going to continue defrauding the American people until a wave of consciousness sweeps across this nation's minds, and collectively people become aware of what I've been teaching for 50 years. The 16th Amendment didn't change a thing. No new taxes authorized, no new subjects are created. It permanently classifies the income tax as part of the indirect powers which pre-existed the 16th Amendment and have been exercised by the government without protest since the Civil War, basically. So, and if anyone needs help dealing with the IRS and the DOJ, find your way over to irszoom.com, where I will help you assert your rights under the law and help you to be one of the folks exposing this fraud, both to the American people and inside the government, where we're teaching them the application of the law, and they have no answer. They can't answer anymore, because it's just like trying to argue Roe v. Wade is still in existence, or Chevron is still in existence. It's all gone. Affirmative action is gone. Abortion under Roe v. Wade is gone. Chevron regulatory deference under the Chevron doctrine is gone. And direct taxation under the 16th Amendment is gone too. So, we're going to talk some more about that in a bit. But, I thought today I'd take some time and talk about what's happening here, because for the first time in like 5 years, there's no crime in D.C. Donald Trump has cleaned the place up in 3 weeks. The crime is off the streets. They've got hundreds of gang members and career criminals who've been arrested and not released on their own recognizance or on bail back onto the street to continue terrorizing the people of D.C. And the crackdown has scared away all the ones who haven't been arrested. They're not on the street committing crime openly and with audacity, unabashedly, knowing that they're not going to be prosecuted and the crimes aren't going to be recorded as felonies, only misdemeanors. Everything has changed under the federal police force, and people are actually starting to enjoy going out in the evening in DC for the first time in 4 years, because it's been almost prohibited while Biden was in office. The crime in DC has gotten worse every year until Trump took office here and said enough is enough, we're taking back our city, and rightfully so. And they're not out terrorizing civilians. They're arresting the career criminals and the gang criminals, the people doing the carjacking and the blatant shoplifting and other crimes. So DC is actually habitable again. We'll see how long it holds up and how long the president stays place. He has federalized the DC police force, and I'm not sure how long that can go on. At some point, they'll have to turn it back over to DC, but you know, you need a new mayor and a new chief of police continue the Trump policies rather than revert back to the Democratic policies of not arresting, writing down the level of offense, and then releasing on bail the career and gang criminals to do it again. So that actually is working. And what else is working, apparently, for first time in 5 years, is the New York court. The New York appellate court overturned Trump's $500 million judgment in the fraud mortgage case prosecuted by Letitia James. Now, they should have overturned the whole case, and I'll talk about that in a minute. But they basically tossed out the entire $500 million judgment, overturned it as an unconstitutionally excessive fine, basically, which is how it was written up by one of the judges expressly. But they tossed it as being unwarranted and excessive, and that's probably going to throw it back into the court to be redetermined because they didn't address the conviction, which they should have. And this is the case now, if you remember back when it happened, like, what, 4.5 years ago or so? This is the case that I said Donald Trump's attorneys should never have allowed him to make a plea. The court never established its subject matter jurisdiction to conduct the trial. The whole trial was based, allegedly, on misdemeanors for which the statute of limitations had expired. So these are unprosecutable misdemeanors in the New York courts. And they were the basis for leveraging those expired misdemeanors into a felony by claiming they were committed in conjunction with another statute that was violated to create a conspiracy. And the court had identified for it only the misdemeanors in New York that had expired. But how did we get to court? Oh, under the felony, which is leveraged. Oh, well, what's the statute that leverages the misdemeanor into a felony? That question was never answered. If the question of what statute was used to leverage the expired misdemeanor into a felony, you don't know what you're pleading to. Are you pleading to an expired misdemeanor? Or are you pleading to an unspoken conspiracy charge that isn't identified? It's too vague and nonspecific for you to offer any defense or plea, knowingly understanding the charge. So it's impossible to understand this charge because there's no other crime identified as having been violated to join with the expired misdemeanor to leverage the charge into a felony, which the court said it could conduct a trial for, the felony, not the misdemeanors. The two together acted to create a felony. It doesn't matter that the misdemeanor had expired. It was violated with an intent to combine the violation with another statute to accomplish an unlawful end, which they said was Trump getting more money on his loan than the property was worth, which of course is all nonsense because the properties were worth what they were loaned at. But anyway, without the second element of the crime, creating the felony, being disclosed, you don't know what you're pleading to. So you can't plead, and they never should have pleaded. And look what happened when they did plead. when they did plead, they went through the entire case without the second element ever being disclosed. The jury was never told what the second element, it was alleged to be some campaign election law violation. But that was never argued or disclosed. So the jury verdict, they went to the jury trial. Now in New York, in closing arguments, the defense goes first. So after the whole case was argued and the defense argued its cases and points, they did their closing argument, and then the New York prosecutor's office got up and said, oh yeah, by the way, the law that was the underlying felony was a federal election law, so find him guilty. Now here's the problem. The defense has no opportunity to respond to that. That alleged foundation should have been disclosed in the beginning. The fact that the prosecution didn't disclose the foundation for the case until after the defense had made their closing argument is completely illegal. It's a violation of due process. The court conducted the whole trial without subject matter jurisdiction. And then after the defense has lost all opportunities to speak, then the prosecution makes an allegation that can't be answered. And of course, the allegation they made that it's a federal election law, the New York state courts got no jurisdiction over federal elections. There was no conviction of Trump on that matter to point to. It was pure speculation, and the state convicting him of an allegation that had never been made in the court. And it wasn't a state election law because there was no state election that Donald Trump was involved in. It was a federal presidential election. So state campaign law doesn't apply, even in New York, to federal election law. That's controlled by federal law, which the state courts don't have jurisdiction to try. So the jury was falsely misled into believing that a statute had been violated that the court had jurisdiction to enforce that leveraged the expired misdemeanors to let them render a verdict, and none of it was true. Absolutely none of it was true. His attorney should never have let him plead to this case, and the New York Appellate Court should have tossed out the whole judgment with the case. And I think that's what's going to happen on higher appeals in New York. I think they go to the highest appeals court in New York next, and then the Supreme Court. And then it would go to the U.S. Supreme Court. But at some point, they're going to toss this whole thing for a fraudulent prosecution by a court that lacked the subject matter jurisdiction. The state court did not have the ability to combine an alleged federal election law with a state allegation to create a felony. They have to be state laws or a federal fact, which could only be determined in this case by an adjudication of guilt on an election law violation by Trump. And that was certainly looked at, and they walked away from it because there wasn't any election law of violation. So the federal had already investigated and walked away from it. The state picked it up and pretended like it had been a done deal in the courts. So all of that trial was absolutely 100% fraudulent. They should throw out the whole thing. Trump's attorneys really blew it by letting him plead to the case. And it was just as fraudulent as that Mar-a-Lago case where they engineered a criminal raid without any criminal investigation. He'd already turned over a whole bunch of records on a subpoena in December, and the Justice Department knew he wouldn't turn over anymore. So they wrote up a subpoena that said, give us everything else you have, essentially, and served it on him in March, knowing he would refuse. And then after refusing the abuse of an excessive subpoena, when he'd already complied earlier, then, without going to the judge to have the subpoena enforced, they raided his place in Mar-a-Lago to criminally charge him without an investigation, just because he wouldn't comply with an excessive subpoena. Since when do you take a civil case and go right to criminal because they won't give you a subpoena? You ask the judge to enforce the subpoena. Okay, I hear the first radio commercial break coming up. This is Thomas Fried on the Liberty Works Radio Network. We'll be back in 5 with more. Okay, this is Thomas Fried on the Liberty Works Radio Network. This is the Truth Attack Hour, and let's just get right back into this. You know, when the commercial break came up, I was talking about how the Mar-a-Lago case against Trump was also a complete and total fraud. It was a matter where, in civil litigation, where Trump's refusal to comply with an excessive and abusive subpoena after he'd already complied with an earlier subpoena, so the government knew he wasn't going to comply with this to give them everything else. They engineered the refusal. Now, normally in a civil case, when one party refuses a subpoena from the others for documents on some legal argument, like presidential privilege, maybe, but when there is a basis for the refusal rather than just a no F you, we're not going to do it, which is not the answer they got. They got presidential privilege basis for cause. Now, in that case, you're supposed to take your subpoena and their reply to it and go to the judge and say, look, judge, we moved them for this, which we think is reasonable and we need, and they have, and they won't give it to us. And the judge looks at it and says, well, their argument isn't terrible, or their argument is terrible, you win, here's your order. In this case, the judge would have to say their argument isn't terrible. We have to litigate this. Let's have a hearing. Let's everybody come in and we'll discuss this in the civil case, and I'll issue a ruling as to whether or not this civil subpoena will be enforced or not. So that's what's supposed to happen. But when Trump refused the civil subpoena, what the government did, without any criminal investigation, they took the matter and immediately went to a judge for criminal warrants to raid Mar-a-Lago. Now, what corrupt judge said, yeah, okay, not you should go to the civil judge, you should go to the judge in the civil case and get this order from him? Why aren't you in civil court? This is a proceeding in civil court. Why aren't you asking the judge to enforce your subpoena? Where's the criminal investigation serving as the basis for a warrant to raid the president's home? Oh, there isn't any. We just think you should give us this stuff for the civil case. And we think we might find something criminal in it, because there's no criminal allegations, because they didn't know what there was. So it was all criminally speculative. No evidence whatsoever. It was in civil litigation. It was civil process, no criminal investigation. And some crooked judge, liberal Philistine, some Pharisee, said, oh yeah, go ahead, raid the president's home in Mar-a-Lago. So the agents went in and staged all the documents on the floor so they could take their picture, labeled classified documents, like it was all laid out like that. What utter nonsense. And the judge went ahead and admitted it all. Oh yeah, not a problem. Not a problem. So the whole thing was rigged by the Justice Department, and it was a completely fraudulent prosecution, just like in New York. It was all weaponization of the legal justice system, the Justice Department and the legal system, to try and interfere with Donald Trump's running and becoming president again. All absolutely criminal, perpetrated by the liberal elements of the justice system. Okay, enough on this. You know, I've been talking for, the last 3-4 months about how the Moore decision at the Supreme Court level takes down the fraudulent prosecution and enforcement of the income tax as a direct tax under the 16th Amendment. And the Justice Department's argument is, oh, well, that's a decision about the MRT, the mandatory repatriation tax. In India, that's a case about foreign taxation. Yeah, the case might be about foreign taxation, but what the Supreme Court wrote on pages 5 to 7 are not about just foreign taxation. What the court wrote up was a comprehensive review of the entire authority under the Constitution for the federal government to tax the American people, both directly and indirectly, together with a reassertion of the limitations imposed by the Constitution that still exist with respect to both forms of the allowed taxation, direct and indirect, where all direct taxes must be apportioned to the states under Article 1, Section 2, Clause 3, to the states for payment. No direct tax can ever be laid on or demanded from an individual. Article 1, Section 2, Clause 3, all representatives of direct taxes shall be apportioned amongst the several states. And 914, Article 1, Section 9, Clause 4, says it has to be apportioned in proportion to the census. And more, the Supreme Court reasserts that both of those limitations, proportionate imposition to the states, applies for all direct taxes. Now that's domestic taxation, not just foreign taxation in a foreign country. That's about direct taxation. The limitations are still there. They're not removed by the 16th Amendment because the 16th Amendment doesn't create a new power to tax directly. That's a fraud too. The Supreme Court says that income taxes are indirect taxes under Article 1, Section 8, Clause 1. And it explains that the 16th Amendment is a reassertion of that Article 1 authority without the creation of any new power to tax, neither directly or indirectly. And it is not an assertion of any new creation of persons subject to tax, newly made subject. There's no expansion at all of the taxing powers by virtue of the adoption of the 16th Amendment. It did not expand powers, not the objects, not the subjects, not the persons. It further explained and limited the tax to the confines that it had always been limited by, and that is, it's not a direct tax that has to be apportioned, so it's perfectly okay for the tax under the amendment to be without apportionment because it's indirect. And indirect taxes don't have to be apportioned. They only have to be uniform, which is what we want to talk about next. Uniformity of the indirect tax. So it's not legitimate as a direct tax without apportionment, without limitation, because there is no new power to tax directly. So it's an indirect tax. It has to be uniform. Now, is the tax uniform with respect to its application to the citizens? And I say, no, it's not. How can it be uniform when the rich pay 40% and the poor don't pay anything at all, or 10% at the most? That's not uniform. That's class legislation. Now, the court and the government's answer has been, well, uniformity. That doesn't mean intrinsic uniformity. That means geographical uniformity has to be applied. And that means that as long as the tax brackets are applied to the different classes of persons created by the statute, as long as they're applied equally in every state, it's okay to have graduated tax brackets that apply. Now, these decisions saying that graduated tax brackets can be used date to a series of Supreme Court decisions in the 1880s where the court says the power to tax by graduated brackets is based on the power of Congress to discriminate against the commodities and articles of commerce subject to taxation. And I would add, to discriminate against the inanimate corporate person and the licensed and privileged person and the foreign person whose privilege is being allowed here. And the basis of the discrimination is that Congress can tax against these privileged parties and inanimate articles and persons based on the amount of revenue, income, profit realized as a result of enjoying the privilege that they possess, i.e. incorporation or a license, so that because of this higher level of return from the privilege, say a company making $10 million from selling alcohol, tobacco, and firearms, or making money from any source, can be taxed at a higher rate than a company only making $100,000. So this was the basis of graduated brackets, the power of Congress to discriminate against the objects and parties being taxed. And they do have the power to discriminate against the corporate person, the licensed person, and the foreign person. And the alcohol, tobacco, firearms, and other commodities subject to tax, inanimate articles. Congress can tax them at different rates depending upon how much money is being made by the parties importing, exporting, transporting, or selling the articles. But what happens when you apply this theory of the power to discriminate, which was only applied at the time in the 1880s, without regard to or respect for or thought for or consideration for the inclusion of the American people within those tax brackets? Because that wasn't part of the law in the 1880s. So what they're discussing is the power to discriminate against parties other than the citizen. The corporate person, the licensed person, the foreign person, the only party subject to federal taxation in the 1880s. There is no consideration for the use of brackets with the American people. There's just this repeated reassertion since the 1880s in all of the Supreme Court decisions saying it's geographical uniformity, it's geographical uniformity, it's geographical uniformity. And I say baloney. Baloney, that's a lie. This is Roe v. Wade. This is Chevron, regulatory doctrine. This is affirmative action. This is all nonsense. Why? Well, let's test this theory of geographical uniformity being the basis for allowing Congress to discriminate against the American people. What say you? You think that Congress could write a law, say that taxed Jews at 90% and Christians at 10%? Or blacks at 5% and whites at 95%? Or men at 75% and women at 25%? Or Italians at 50% and Irish at 10%? Or Saudi Arabian people at 90% and Swedish people at 0%? Or gay people at 80% and straight people at 10%? Would any of that be legitimate for Congress to discriminate against the American people on any of those bases? What do you think? Think they'd be allowed to discriminate on the basis of religion, gender, age, sex, education? What do you think? Think they'd be able to discriminate on any of those bases? National origin, sexual preference, anything? Yeah, of course not. Absolutely fraud. Oh, but if you take geographical uniformity as your basis to allow discrimination, well, then it's perfectly fine to write these laws, as long as all the Jews, blacks, Christians, Muslims, Hindus, gay, straight, are treated the same in all 50 states. You can write laws that tax the Jews at 90% and Christians at 5%. And as long as the Jews in New York, Illinois, Texas, and California, and Florida are all taxed at 90%, it's perfectly okay. And I say, baloney. It's all fraud. The uniformity required under the Constitution, Article 1, Section 8, Clause 1, with respect to the taxation of citizens, demands intrinsic uniformity, absolutely equality, and equal rates of tax on every person, regardless of race, color, age, gender, national origin, sexual preference, or revenue, income or profit, wealth or property. None of it can be used as the basis for discriminating against the American people. Either everyone is treated the same or the tax is unconstitutional. And there is no tax that reaches the labor of the American people. Impost, duty, and excise don't tax labor. And it's not the basis for gross income making you taxable. Okay, I hear the second commercial break coming up. This is Thomas Freed. We'll be back in 5 with more on this gross income issue. Okay, this is Thomas Freed on the Liberty Works Radio Network. Let's just get right back into this. As we came up on the commercial break, I was talking about Section 61 and gross income, which has become the basis for the application of the tax as a direct tax under the 16th Amendment. Remember, I said that geographical uniformity doesn't hold water when you test the theory with other forms of its application. So geographical uniformity is nonsense. The direct tax is gone. As an indirect tax, the income tax, as a graduated tax, is not uniform. Of course, where you do find the graduated taxation of income is in the second plank of the Communist Manifesto, which is repugnant to and destructive of the constitutional law prohibiting direct taxation of the citizens. That's where you find the population controlled by the state, divided into classes to fight amongst itself, empowering the state, furthering the socialist operation of the bureaucratic state. It's not in the Constitution. It needs uniformity so that the people can ally with one another rather than against each other and with only one party in the government, because of course the political end result is that no politician can ever represent the entirety of the population ever again. It has to pick one class or the other, dictated by the tax brackets, and spend its entire time arguing for that class or being tossed out of office by that class members. And that means no legislation gets written for everybody. It only gets written for special classes. And guess what happens when you let Congress write legislation only for special classes? They get controlled by the rich, who make sure that Congress only writes legislation that controls the masses, not the rich. So you get ruled by an aristocracy that controls the bureaucracy through the funding of it through the higher levels. And of course, you get ruled by the bureaucracy, especially when Chevron says they can write their own laws to rule you, and everybody in the court has to obey the bureaucrats and their regulations. And it doesn't matter if the statute doesn't go that far. We're going to let the bureaucrats rule us instead of being limited by the statute. And that's exactly what they did with the income tax. They wrote their own liability under regulations. It's not in statute, but they needed to come up with some way to claim you had liability for a direct tax. It's not there in the statutes. They got around the the basis for taxation with the Section 61 gross income argument, which I think is still the case. The Supreme Court's got it correct. This is a Glenshaw Glass in 1955, 1 year after the recodification of Section 61 from Section 22A. And all of a sudden, in 55, under Glenshaw Glass, Section 61 is Congress exercising its taxing power to tax all accessions to wealth. What constitutional basis would that have? Imposts, they tax foreign activity, not all accessions to wealth. Duties, they tax exports, not all accessions to wealth. Excises tax commodities, licenses, and corporations. Privileges, not all accessions to wealth. Where's the constitutional foundation for a tax on all accessions to wealth? That's not addressed in the Glenshaw case. They just declare 61, Congress exercising authority to tax all accessions to wealth. I think assuming a direct tax under the 16th Amendment without saying that. And then Section 61 becomes the focus and basis for enforcement, not constitutional authority. And they've gotten away with the swap for 70 years. But now that the direct tax is gone under the 16th Amendment, so too is the argument that Section 61 is a basis for you being taxable, because rent earned in the 50 states as private property isn't subject to an impost, a duty, or an excise. Interest isn't subject. Commissions, alimony, tips, wages, salaries. None of the things listed in Section 61 are taxable by impost, duty, or excise unless they're earned by a foreign person, a licensed person, a corporate person, or in a foreign place like the possessions of a foreign country under tax treaty. Only impost, duty, and excise. You got to go through step 1 before you get to step 2. What's subject to the impost, duty, or excise? The gross income earned under the privilege possessed. But without the privilege, without the taxable activity or transaction or event or in a taxable place like the possessions of a foreign country, without federally taxable activity subject to impost, duty, or excise, there is no gross income that's taxable. It doesn't exist. And we only get here. So I think Glenshaw Glass is another decision that needs to be attacked. And I think we're rapidly approaching the point in time where we need to attack Stewart Machine, which replaced Alton Railroad. What happened here is in 1934 or so, under Roosevelt, Congress wrote the first Social Security Act. It got challenged and went to the Supreme Court in the case of Alton Railroad. And in Alton Railroad, the court wrote that Social Security is unconstitutional. The power for Congress to legislate for the social well-being of the future citizens is outside the orbit of congressional power. Outside the orbit of congressional power to write law for Social Security. So the court struck down as unconstitutional the power to tax labor for Social Security. And then Roosevelt won re-election in 36 with the Democrat majority. And then went right back to work and wrote another Social Security law. And I'm not sure about this, but I think the only difference in the new Social Security law is it wasn't mandatory, it was voluntary. You had to sign up for it instead of it being mandated on you. But Congress wrote the bill, and Roosevelt went to the Supreme Court and said, paraphrasing, if you assholes don't let this second Social Security bill pass, I'm going to stack the court with 6 new members, 1 for every justice over the age of 71, and you will never have another conservative decision in the history of your service on the court. So after Roosevelt threatened to stack the court with 6 new liberal members, the case challenging the second Social Security Act arrived at the court in Stewart Machine, 1937. And all of a sudden, 2 years later in Stewart Machine, oh, it's employment. Well, taxing the whole means you can tax the components. So Social Security is perfectly okay now. But they only addressed the tax from the aspect of the employer paying it. They didn't address it from the aspect of being a direct tax on labor of the citizen. But Stewart Machine is now the basis for the government claiming it's okay to tax your labor. But it was only written by a court that was extorted by President Roosevelt into abandoning the position that it had just previously declared 2 years earlier in Alton Railroad, which is the correct decision. There is no constitutional authority to tax your labor for Social Security. And that's still evident in the fact that you have to apply for the number. It's not mandatory, it's habitual, it's de facto, but legally it's not mandatory. The government just has all the employers administering it as though it were, and all of the institutions using it as identification when it specifically is prohibited as being identification. The only identification document the federal government is authorized to issue is a passport. That's it. There's no federal ID number. Social Security is not to be used for identification. It used to say so right on the bottom of the card. It's not lawful for parties that are not your employer to demand a Social Security number as identification. It's not lawful. It's peonage debt service. It's involuntary servitude and de facto practice. Because giving the financial institutions your number connects the number in your account to the IRS through the 1099 reporting interest or dividend or the existence of the account. And now the government can order the overseer, the institution, to keep you an enslaved peon in debt service, turning over your property to the government so they can pay it over to the Federal Reserve Bank, which is where all the money taken from your paycheck goes. It doesn't go in the United States Treasury. We don't have a tax system. The law, Title 26, Section 7809A, says every penny collected for tax has to be deposited in the U.S. Treasury, and a receipt has to be created showing the name and account number and amount of tax paid. And that name and account number is you and your Social Security number. The amount is the amount withheld. So they have to deposit it on a daily basis under 7809. Now, regulations modify that to some regular cycle, and most employers send in their withheld escrowed taxes on a quarterly basis. But that means on December 31st or January 1st or 2nd, by that time, all your withheld money should have been sent into the Treasury, and receipts should have been created after each quarterly deposit showing your name, number, and the amount paid. Well, if these receipts exist, why do you have to file? The tax has already been recorded as being paid. Oh, you have to file because there is no record of your paying tax. There's no record of your paying tax till you file. That's why you have to file, to create a record of tax paid. But the law says when it withheld, it should have been paid. So where'd the money go? Since there's no record and no receipt, your employer sent it in. He's not the one cheating you. Somewhere inside the government, the money got rerouted from the party designated on the check, either IRS or U.S. Treasury. It got rerouted around the Treasury to the Federal Reserve Bank. Want proof? Look at the back of the last check you sent to the IRS. See who cashed the check. See if, like the law requires, it says deposit to the U.S. Treasury. Because, of course, tax is money for the government to spend. And if it's not in the Treasury, Congress can't write appropriation bills against it to spend it. They can't appropriate funds from the Federal Reserve, only from the Treasury. The money was taken from your paycheck telling you it's tax under a tax withholding allowance form. So how come it didn't go to the Treasury as required by law? It didn't go to the Treasury because it's not tax. On April 15th, when you filed, you're given a credit for tax for all the involuntary debt service, the peonage involuntary debt servitude that you contributed to collateralizing the $37 trillion in debt, which collateralization, as long as the Treasury, as long as the Federal Reserve Bank sees the people collateralizing the debt, they're going to continue allowing Congress to spend you into oblivion. 37 trillion and counting. That's where your money goes. It doesn't fund the operation of the government. It goes right to the Federal Reserve Bank to continue the peonage involuntary servitude debt system we have in place of taxation. As goes the currency, so goes the fate of the nation and the quality of life of the American people. We either rein in this system and control it, stop it and end it and put in place and restore constitutional taxation, or we will soon reach the cliffs of oblivion with all the other lemmings racing downhill to their own destruction. We'll be back next week, possibly with the solutions. Okay, this is Thomas Freed on the Liberty Works Radio Network. Tell your friends, spread the word, get tuned in every week, and check me out on the Thomas Freed YouTube channel you can link to off of taxfreedom.com.